Hey guys, John Wiehn, attorney and legal instructor with Blue to Gold law enforcement training, coming to you today with another Roadside Chat. Today's question is from an officer in California, and the question is this. A suspect is in custody for burglary. He makes a valid Miranda invocation on the burglary case and remains in custody. We want to re-Mirandize him on an unrelated case with no break in custody. Can we obtain a valid Miranda waiver, or does Maryland v. Shatzer prevent this without the attendant 14-day break in custody? There's also a caveat. It says, can we use a Beheler admonishment to obtain valid waivers from in-custody suspects who have invoked their right to counsel on a different, unrelated case? So the second part of that indicates to me that when he made his valid Miranda invocation, it was for his right to counsel and not his right to silence. But let's address both. So first off, if a suspect invokes his right to counsel, then that's going to be a much more difficult situation. If he invokes his right to silence, then Michigan versus Mosley has held that as long as you scrupulously honor that invocation of the right to silence, you can reinitiate after a cooling off period. In that case, there was a 2-hour break, a different detective asked about a different crime, re-Mirandized, obtained a valid waiver. The court said that that was sufficient. He was originally arrested for armed robberies. He invoked his right to silence. 2 hours later, a different detective came in and asked him about a different crime after obtaining a valid waiver, and he eventually made incriminating statements regarding a murder. Court said that was good with regard to a right to silence. Now, your right to counsel is going to be a much more stringent standard. All right, so Arizona versus Edwards is kind of your first case here, and basically in that case, officers arrested a subject. He invoked his right to counsel. They came back the next day, attempted to reinitiate. They read a Miranda again. They obtained a waiver. He made incriminating statements. And the court held that when a subject invokes his right to counsel, officers may not reinitiate without his counsel present, or the subject can reinitiate. Those are the only two ways: counsel present or subject reinitiates. Arizona versus Roberson was a different case. Subject was arrested. He invoked his right to counsel. 3 days later, a different officer, unaware of the prior invocation of the right to counsel, approached Roberson, read him his Miranda rights, obtained a waiver, and the subject made incriminating statements about a different burglary. And the court in that case said, Edwards still applies. Different crime does not matter. If a subject invokes his right to counsel, you may not reinitiate without counsel present. The subject can reinitiate, but if officers want to reinitiate, only way is with counsel present, even for a different crime. All right? Now, Minnick versus Mississippi said that a subject invoked his right to counsel. He was provided with counsel. Right? He had the opportunity to speak with an attorney. Then officers later initiated again without counsel present. And the court said, even if a subject has had access to an attorney, officers still cannot reinitiate without that attorney present. Right? So we're treating it very, very stringently. Now, Maryland versus Shatzer, basically what they said is a in-custody interrogation is so inherently coercive that there needs to be a 14-day break in Miranda custody in order for an officer to reinitiate and to try to get another Miranda waiver, right? So either the subject can reinitiate or there is a 14-day break in Miranda-like custody if a subject invokes his right to counsel. The only way. Different officer, different agency, different crime, does not matter. 2 ways if a subject invokes his right to counsel. Either the subject reinitiates or you have a 14-day break in Miranda-like custody. The only way. The question about can we use a Beheler admonishment, and basically what Beheler does is Beheler says you're trying to kind of remove that arrest-like custody. And so you tell the subject, hey, you're not under arrest. You don't have to answer my questions. You can stop answering my questions at any time. Beheler, California versus Beheler is not going to apply in this case because the subject is in custody, right? He's under arrest. California versus Beheler, that Beheler admonishment would only work if the subject was not actually under arrest. And so the idea of using a Beheler admonishment to obtain valid waivers from in-custody suspects who have invoked their right to counsel on a different unrelated case, that's not going to fly, right? Not going to fly. So again, if a subject invokes his right to counsel, there are only two ways where you can question him. If he reinitiates, or there's a 14-day break in Miranda-like custody. That's it. All right. I hope this helps, guys. It's difficult stuff. If you want more information on it, I highly recommend you take our Advanced Criminal Investigations class because we do a deep dive into every one of these cases, and it is mind-blowing for a lot of officers. If you guys have any questions for us, please don't hesitate. bluetogold.com/show, bluetogold.com/show. Submit your questions, and we will do what we can to help make sure you get it right every time. Until next time, be safe, and we'll see you soon.